of all, can I reassure you and the committee that whilst Clause 47 has important qualifications within it, it does not exclude the court's ability to judicially review these regulations. There was never any intention or effect for there to be a general ouster of judicial review. And that was confirmed, I think, by the Office of Parliamentary Counsel, of course, are responsible for drafting these provisions. And of course, these provisions themselves were amended by the government, which I think demonstrates the care and thought that's gone into making sure that there wasn't inadvertent breadth to this particular provision because of the sensitivities that naturally exist around it. I think that, first of all, with regard to the drafting, clear words are certainly required to prevent the court's jurisdiction to judicially review the regulations. And the regulations made under clauses 44 and 45 are, of course, capable of being judicially reviewed under ordinary public law grounds. And that includes what I think everybody is familiar with, grounds of vires, rationality, legitimate expectation. All those questions are entirely legitimate questions that can be raised by applicants who seek to challenge these particular provisions. I do accept, of course, that Clause 47 goes that bit further by providing that courts cannot find the regulations to be unlawful by reason of their incompatibility or inconsistency with a rule of domestic or international law. And that includes inconsistency or incompatibility with the EU's own interpretation of the application of the state aid rules, for example, in Article 10. Now, I think all of us would agree that inconsistency with international law isn't what we would regard as a standard ground for judicial review. But I felt, and indeed the government felt, that it was important that that position was clarified so that there was an increased certainty when it came to these particular provisions. And also when it came to the time limits, bearing in mind the different jurisdictions, of course, we have in the United Kingdom, it was important that there was consistency there as well. But as a result of the qualifications and amendments made by the government, I think there is greater clarity about the Human Rights Act aspects of the notwithstanding clause. It doesn't mean that the court won't be able to take into account relevant European Court of Human Rights judgments, for example. And it does oblige a minister, when making regulations, to make a Section 19 statement as well. Public authorities who act pursuant to these particular regulations will remain under the duty to act compatibly with convention rights. And therefore, I think that whilst there are qualifications in this particular clause, they are not of a type that could be reasonably argued as creating either a fundamental ouster or even a significant ouster to the rights of individuals and groups to challenge by way of judicial review.
Lord Pannick, did you want to come back on that?
Yes, may I? Because I have some difficulty with that, Lord Chancellor. I entirely understand your point that the domestic court should be prevented from considering compatibility with international law. But this clause goes much further than that. It purports, as I said, to prevent the court from finding these regulations unlawful because they are incompatible or inconsistent with any rule of domestic. Why is it then that these regulations could be challenged for uncertainty, retroactivity, matters of that sort? Surely that falls plainly within the language of this very broad exclusion. That's my difficulty.
Well, Lord Pannick, I absolutely understand the point. I would say this, that there needs to be a balance between making sure that the fundamental right of judicial review is not ousted. And, I reassure the committee and indeed everybody listening that is definitely the government's intention. We do not seek to oust JR. But there has to be also some degree of certainty with these regulations. And again, I go back to the context within which they might be used. They would be used in order to achieve and to safeguard a position of unity within the United Kingdom internal market, the position of Northern Ireland within the Union of the United Kingdom, and the sort of fundamental questions and issues that I think a responsible government has to face up to. And I don't make any apology for seeking to, through this particular provision, obtain as high a degree of certainty as possible. And therefore, I think probably we will be returning to this argument over the next few weeks and months, Lord Pannick. But what I wanted to convey to you was that actually between us, there isn't a fundamental philosophical divide. There is I think, a more subtle argument here as to where the balance should lie between the right to have an unfettered access to judicial review and also the national interest, we would say, as a government, in obtaining as much certainty as possible with regard to the application of these regulations. And I think that's where the argument will lie. And I look forward to hearing the debates ahead in your Lordship's house.
Yes, could I, with the Chairman's consent, just come back once more, because there is a philosophical distinction with respect between us. I cannot see that you can claim credit for not excluding judicial review, while at the same time, Clause 47 immunises any regulations from any change by reference to any principle of domestic law. That's my difficulty.
Well, as I've said, Lord Pannick, I do not think in all earnestness that the difference is that dramatic. I think whilst I certainly don't suggest that you have used any language that perhaps could be described as romantic or emotional about this issue, there are others who have. Can I just put it on the record that we are not, and I will not tolerate as Lord Chancellor, any unintentional or intentional slide into tyranny as a result of the potential passage of these measures. This is all about balance. That's all we're trying to achieve. And I'm sure that through the debate in your Lordship's house, we will learn more and have the sort of detailed debate that I think that this particular clause deserves.